Order, order. Very warm welcome to Professor Bowles. We've read your work with great interest, and in a moment we're going to ask you to expand a bit on it, but I think we have to declare interests first. If I start on this side.
In the past, I've undertaken publicly funded work, both in legal aid and criminal, as a solicitor and a member of the bar.
Mr. Buckland.
Yes, I'm a barrister who has conducted legally aided work in the past. I don't have any current cases at the moment, though I am still due some outstanding payments from legal aid work.
Thank you very much. And to return to your research report, we found it very helpful and interesting for our inquiry. Have you done any work since then which has in any way modified the conclusions in the report, or caused you to think that there's some points that you might need to go back to more systematically?
No, I haven't. I haven't had a history of doing a lot of work in the legal aid sphere. This piece of work was commissioned by the Ministry of Justice in 2008, I think it was. But I haven't done anything of substance since I wrote this report.
It's just to give you an opportunity to speak more generally about it. How would you sum up the reasons for us having a legal aid system which, in the words of the Lord Chancellor, is one of the most expensive in the world? In fact, which seem to be sustained by your work.
I think one of the main points I'd like to make is that really I think there are a lot of reasons why we are spending so much more than other countries. I think it's to do partly with the history of legal aid, what it was set up to do and how it's grown subsequently. It's to do with the way in which people have become accustomed to resolving disputes. It's to do with the high crime rate in England and Wales, and the comparatively high proportion of criminal cases which come before the courts. I think there's a long list of reasons which perhaps we'll go into in greater detail later on. I don't think there's any single reason that says that we're being particularly profligate. I think it's not quite a perfect storm kind of argument, but on almost all of the components of the expenditure, we find ourselves in a position where we're spending more.
We've also had the Council of Europe document,
yeah,
which I think you share some basic data with, don't you?
Yes.
Where we seem to come out top of the table most of the time, don't we?
Yes, we do, yes.
Elizabeth Truss.
Thank you very much. One of the points you made about the drivers is that there are a variety of different drivers, but one thing I notice looking at the statistics is we have a very high cost per case. So even if the crime rate is higher and more people are eligible, there still seems to be an issue with the basic cost per case. How would you compare that particularly to the other common law countries that you did in your study?
Well, I think the high cost per case depends on a lot of things. I mean, it's to do with the amount of legal services which are used in cases, the way in which the expenditure on services is managed. It's to do with, I think, some procedural issues which seem to make the volume of cases, particularly criminal cases, going before the courts particularly high. And I mean, in terms of why the cost per case is higher, I think that has to be primarily to do with what the legal inputs into a typical criminal case entail.
So are you suggesting that compared, let's say, to Canada, that legal service is more expensive here, or the court process is more elongated, so that people need more legal services during that case? What could potentially be done about that?
Well, it's very difficult to make direct comparisons of the amount of what the lawyers in the cases are actually doing, which I think is one of the things that one would like to try and get at, because it's that and the cost per hour or the cost per step that one's trying to control. In terms of comparisons with other countries, I think it's very difficult to pin down why it's costing so much here. I mean, I think what has evolved is a system for, as it were, rewarding people who are doing criminal legal work, and they're working in a set of procedural and substantive rules which, as it were, constrain what steps have to be followed in a case. And it seems that those things just seem to be taking longer in the UK than they would elsewhere in England.
Can I try and separate that between the way that the Ministry of Justice is implementing the body of law and just the extent of the body of law in Britain and the way that laws are drawn up? What's the division between those? And also, could you possibly comment on the cost per hour between Britain and other countries, whether that's a factor?
I think the distinction between the substantive law and the procedural issues is, I should say that I'm an economist and not a lawyer, so there are a lot of parts of this which I find quite difficult to answer authoritatively. But I think the sorts of issues that tend to come up are things like at the magistrates' court, when cases are being heard that potentially could go to the Crown Court or could be resolved in the magistrates' court, that's a point at which costs seem often to run out of control, because the sort of structure of the incentives for the lawyer to terminate cases at particular stages, to decide whether to go to the Crown Court, whether at the stage of a Crown Court hearing having been set down, they then make a plea late in the day, and everybody wastes time. And the resources are not just the legal aid time, but of course there's court time as well, which is very frequently wasted in these kinds of cases. And I think it is. I mean, one of the things which emerges from the comparisons with other countries, I mean, again, it's difficult to pin down very precisely, but the way in which courts work, the way in which they hear cases, the role that's assigned to the person who's making the decisions relative to the what matters have to be discussed by legal representatives, those things tend to be somewhat different. And one of the reasons why spending is very high here seems to be that an awful lot of criminal cases end up with lawyers appearing in court, and that's something which in other countries has been controlled to some degree.
Even in some Commonwealth jurisdictions.
Yeah.
And how do they do that? Why has Britain taken a different path, or England and Wales taken a different path from Canada or New Zealand in that respect?
I can't give you a straightforward answer to that. I mean, I've looked at the expenditure figures and those sorts of things, but I don't know enough about the differences between the detail of legal procedure in criminal cases to give you a good answer to that. And
can I ask you again about the hourly charge? Do you have hourly rates?
Yeah, I mean the hourly charge is again that's a difficult one, because the hourly charge does depend on the complexity of the issue, what kinds of level of the court is involved, what kinds of lawyers are being used, whether there are counsel involved in those sorts of things. So, I mean, I think what one would say is that the ways of trying to control that spending per case are something which I think is under review at the moment, and that people are looking at alternative ways of setting hourly rates, and that's, I guess, something which they'll be interested to look at more closely.
Sorry, just one more question on that. is there an average hourly rate figure, even if there are going to be differences according to the complexity of the cases? And do other jurisdictions pay lawyers in different ways? So are there more flat rates, for example, than hourly rates, or?
Well, I think even here, there's quite a lot of the work through the magistrates' courts is dealt with on a flat rate basis, so that which is clearly the best way of controlling the possibility that lawyers might try to use longer on cases than, strictly speaking, they merit. But I can't give you a straightforward answer on the hourly rates, I'm afraid.
On family work, you said that even though there had been a slight, over the period you studied, a slight decline in volume, the share of family work on non-criminal spending had increased sharply as costs had more than compensated for a small fall in volume.
Yeah.
Did you identify where those costs were?
No, that's the point at which it's difficult to sort of get much further behind the sorts of figures that we were looking at. This was a relatively small-scale study that we did, I should say. We didn't go into great depth. There's a lot of countries and a lot of different areas of law and so on to try and digest. I think the sorts of things that people would probably argue is that third-party interests, for example, in family law cases, became more prominent over that time interval, so that the interests of children, the interests of people beyond perhaps a husband and partner were being taken more seriously, and that clearly requires a greater degree of legal representation for those wider interests.
Mr. Buckland?
Yes, well, I just wanted to come back and ask you about the point that was made about hourly rates. Did you find that, frankly, an impossible exercise? Because hourly rates are only charged in certain areas of legal aid, for example, very high-cost cases in crime, and the bulk of criminal work is, in fact, per case under a graduated fee scheme.
Yes, I have to say that, whether one's looking at England and Wales or at other countries, sort of pinning down a price per hour of service is a difficult exercise to do, because it depends on things like how you treat preparation time and things of that kind, and what you do about lawyers who are left waiting in corridors for lengths of time and so on. I know that these things can be dealt with sort of line by line, and you can have different rates attaching to different types of input into a case, but it is very difficult to produce a sort of single figure that one can comfortably point to and say...
Yeah, because a lot of these rates will be per day as opposed to any particular delineation. In fact, the system has been changed quite radically, hasn't it, in the years, the last 20 years or so. Does it come to this, though, that really where we are is that the difference between England and Wales and other jurisdictions is sheer volume? That we seem to do a lot more in court, whether it's family or crime, than other jurisdictions? Yeah,
I think that's a large element of it, because in almost all the cases we looked at, the volumes and the cost per case were higher. There has been some good news in the sense that, for example, in the personal injuries area, people have found ways of, as it were, reducing legal spending in those kinds of areas. But the sort of changes that are needed to bring about those kinds of savings are really quite dramatic. I think one of the points I would make about the comparison with other countries is that you can find, for example, countries where income ceilings for being eligible for legal aid are very much lower. Yes. Or you can find countries where the way that criminal cases are handled are very different. I think the point really is that the problem England and Wales has got is a sort of particularly unusual combination of these high volumes and high costs per case, and that's what makes the total spending per capita look so high here relative to us.
Could one of the drivers for high costs in criminal cases be the growth in the complexity of criminal procedure? requiring more work by lawyers on procedural matters than used to be the case.
Yes, I mean, I think that I heard somebody on the radio this morning making the point that an area of law that for which the textbook was 1 volume a few years ago has sort of rapidly ballooned into 5 volumes. I mean, I think from a sort of non-legal point of view, there's good news and bad news about those sorts of things. The expansion of the case law should at some level mean that things are more predictable, that you know how cases in a sense ought to be resolved, so that the growth in the case law should at one level be making it cheaper to resolve disputes. But what seems to happen is that very expansion of things opens up new possibilities for things that, for sort of new avenues that might be explored, new issues that might be taken forward.
Yes, and more complex submissions to be made.
Yes.
Can I just, before Ms Truss comes back in, just ask you about, really the debate we're having here is whether or not there should be wholesale reductions in scope in legal aid, or whether a different or tighter merits test could be applied. In some of the other jurisdictions that you looked at, did you notice any appreciable difference between you've mentioned one about means of payment, but was there any difference in the merits tests that were applied for legal aid purposes?
I think the merits tests tend to be comparatively standard. They're sort of to do with, I mean, people try to get at the notion of whether a private individual with moderate means would spend their own money on the matter. So that kind of test, I think, is pretty widely used. I think the differences come in the way that the service, whether how the advice is delivered, the degree to which representation is needed in cases. I think those are the areas where the differences seem to be most appreciable. That in some of the continental countries, for example, cases that seem to be resolved before they come to a court hearing, and so there are elements of that, of course, in developments in England and Wales, things like fixed penalty notices, where there might be a right of appeal if you're not happy with things, but there are devices that have been used to try to sort of contain the degree to which cases are having to be heard by magistrates or by the Crown Court or the higher courts.
Well, they of course are bearing on the least expensive part of the system, aren't they? They're bearing on the magistrates' court area.
Yes.
Where, as you yourselves point out elsewhere in the report, one of the things that makes our system cheaper, our judicial system, not our legal aid system, is the very small number of professional judges and a large number of unpaid lay magistrates.
Yeah.
But it's them who are it's they who are being saved from parking tickets and things like that.
Yes.
By other mechanisms. That is the trend.
Yeah, I just wanted to. You said earlier that because of the complexity of the system in England and Wales, it would need a sort of radical restructure to bring down the costs. And Mr. Buckland talked about the scope, but what sort of radical restructure are you talking about? And would you have any specific proposals, in line with something like the way the Canadian or New Zealand system worked on a common law basis, for how the court system or the Ministry of Justice could work differently?
Well, I think there's a range of possibilities one can look at. I think if one were looking for encouragement, something like the developments in the contingency fee arrangements in personal injury cases might be a place to look, because in a sense what has happened there is that people have tried to internalise the legal service transactions within the activity itself. So in other words, it's the health service and the injured parties who between themselves are sort of having to sort out the bills for the legal costs of both sides, whereas previously it would have been the taxpayer supporting the injured parties more directly. Now, I mean, I think from an economic point of view, there are 2 points there. One is that that there are ways of, as it were, internalising the disputes to a particular sector. The other is that that there may be other ways of funding the legal costs. So the sort of example that one might think about would be if we take, say, landlord and tenant disputes. At the moment, a tenant who's not very well off will get legal aid to bring certain sorts of claims. What you could imagine happening there would be somebody saying, well, that's really a housing problem, and what we need to do is to sort of internalise the legal resources we need to use on resolving those housing issues within the housing sector itself, so that you might, for example, imagine a scheme where when people enter contracts for the provision of housing, both sides have to indemnify themselves, let's say, against the possibility that there be a dispute and that legal costs would be entailed. So I think in countries like Germany, for example, there's very heavy reliance on legal expenses insurance, which is designed to try to anticipate the sorts of legal problems that citizens might find themselves running into, and to make sure that they've got sort of alternatives to a reliance on a publicly funded legal service. So that would be an example of a sort of rather radical way of going about things. I mean, from an economic point of view, as I say, that doesn't necessarily resolve the issue, because those costs may still be falling on the public sector. It's still the health authority that's paying the lawyers and the cost of the damages. So you don't, although you may get a reduction in the legal aid budget, you wouldn't necessarily get a saving on the amount of resources going into resolving those disputes.
Isn't it potentially beneficial from the standpoint of reducing cost if an authority or a public body has some of the budgetary responsibility for the legal costs that arise from careless decision making or bad decision making?
Yes, I think you can certainly make that argument. I mean, the sort of the incentive effects of those kinds of developments can be quite complex to track, because if, for example, the cost of settling cases goes up, then the legal defence costs for doctors are going to go up, which may be paid by health authorities, or they may be paid by doctors. Or, there are various models you can have of how the insurance arrangements work. So I think it does depend very much on the pool of people who you can rely on to meet the costs at the end of the day, because the disputes have to be resolved, and legal aid or provision of public resources to settle matters can be a costly option. But then I think there's also the issue of what would be the cost of not having those arrangements in place, and those can be considerable for people as well. So I think one of the implications I'd like to, I suppose, draw attention to is that the countries with which comparisons have been made have, as it were, developed these institutions over quite long periods of time, and the legal aid arrangements are embedded in sort of wider structures of things, and to sort of just go in and say, okay, we're going to take that category of work out of legal aid is maybe attractive from a public expenditure control perspective in the short term, but there does become an issue about how those disputes are going to be resolved, because in the end somebody's going to have to put time into it.
Thank you, Mr. Rowland. Professor Bowles, I know you say it's difficult to compare the kind of hourly rates almost of lawyers across jurisdictions, but do you have any idea, even if it's kind of a broadly anecdotal one, about the comparability of lawyers' incomes?
That's an interesting one. I didn't think of looking at that. I suppose the reason for doing that is that the legal professions tend to be very heterogeneous, so that you have distinctions between solicitors and barristers, and a lot of legal aid work will be done by firms which are doing a mix of work. So it's quite difficult to get a sense of the degree to which people, as it were, are getting richer or poorer as a result of the legal aid support in England and Wales. I mean, I think the sorts of comparisons I think one can make. I mean, there are, because clearly from a market point of view, you have to think about what the supply of lawyers looks like. I think the supply of lawyers has grown considerably in England and Wales over the past sort of 10, 20 years, in sort of per capita terms across the population. So I think there are more lawyers about, and they're doing sort of increasingly different sorts of things. In countries like New Zealand, for example, where or Australia rather, where public defenders play a larger role in criminal defence cases, I think there is a case for making comparisons at that kind of level and asking, well, what sort of salary have you got to pay to attract somebody to become a public defender relative to what kinds of income they might expect if they were doing legally aided criminal work. But I mean, I think one of the things that makes the comparisons difficult is that in different parts of the country, the market for legal services is going to work in a very different kind of way. So within a country area, for example, the solicitor may have to have a much more varied portfolio of activity than in a city where they can afford to be more specialist and rely sort of more heavily on legal aid work. I think where you find the sort of well-developed specialist markets, then I think there is scope for making comparison. But I think what one would want to see is, what those. If one were to want to rely more heavily on that kind of an approach, I think it would be important to ask what kinds of developments one would expect, because the experiments that were done here with public defence didn't suggest that there was significant cost savings to be made by going down that route. But I mean, those experiments were comparatively limited, and I think those. From an economic point of view, what one would always want to say is, well, how many options are available in terms of finding a source of legal services? If there are plenty of options, then you can probably be confident the price is going to be somewhat lower.
And in pure market terms, what would be the effect? I recognise that it's only a very small number of barristers and solicitors to whom this applies, but if you provided a cap at the top end of the pay scale, and what in terms of if you limited for lawyers income, the Law Society has suggested £250,000 cap, for instance, and if you were to do that also for barristers, what effect would that have through the entire fee making?
That's a complicated question.
Yeah, that's why I asked you. I'm not trying to catch you out. You're the professor in this thing.
Well, I think I think one of the sorts of things one has to take into account is that when legal aid decisions are being made, for example, about the use of high-cost counsel in criminal defences, there would normally be a test that says that if the Crown Prosecution Service are going to need a QC, then at some level or other you're going to have to say, well, the defence is entitled to one as well. And I think it's those kinds of it's sort of maintaining that balance which is important in circumstances where the Crown Prosecution Service may not themselves be thinking primarily about the sort of cost control implications of what they're doing. So I mean, I think there are important interactions between the provision of legal services and the sort of human rights legislation and the sort of other constraints on how criminal cases.
I mean, it does seem that given the fact we're questioning, I mean, this is a matter of public policy, we're questioning the salaries of chief executives of local authorities, comparing everything with prime ministers. There seems to be one area of publicly funded
work which is conspicuous by its absence from that comparison. And I know it applies to a small number, but nonetheless.
There's trust before I move on.
I mean, is it affected by the large market for legal services? I mean, the UK is a leader in the international legal services market and has some very highly paid lawyers who work all sorts of jobs, whether it's for major corporates or the city. But does that have an effect on bidding up all of the legal work in Britain?
I would guess that it must do at some level, rather. I mean, certainly towards the if you're looking for highly specialist, very experienced lawyers, then I'm sure that does drive salary levels higher than they might otherwise be. I mean, as to what the implications of capping those expenditure levels would be, well, I mean, there's a comparatively small number of people involved. I mean, the question for me would be, how elastic would the supply in the market for legal services be? And I mean, I don't know what the answer to that would be. I mean, I think it's an interesting question to ask, and actually a rather important question to ask, because because it is clear that those high-cost cases are consuming a significant proportion of the budget, and trying to keep costs down in those cases is an important priority. But then, you know, I think the counter would be that some of the prosecutions, especially in major fraud cases, large money laundering cases, things of that sort, that those cases are becoming very, very complex, and there is a lot of evidence, and you do need good people to be able to sort.
Mr. Thurley.
Can I take you back to something which you said to Sir Alan earlier on about family cases? Did you find during the study period, which I believe was 2001 to 2006-07, that there was a substantial increase in the instruction of guardians ad litem during that period?
That's a very technical question. I haven't got the answer to that at my fingertips, I'm afraid.
Could you write to the committee with the answer, please? With regard to your research in particular, can I just perhaps remind you what Lord Bach said, described the findings as tentative to our previous committee. And two issues were identified in particular. One, particularly the federal systems such as Australia and Canada, he said there was sufficient variation even within single countries at provincial level to preclude comparison from being feasible within the time and space limits. And secondly, as regards European Union countries surveyed, the sources of comparative data were regarded as insufficiently robust to support much in the way of inferences, he said. So what are the key limitations of your research, and are the findings indeed to be interpreted as tentative, as Lord Bach suggested to our predecessor committee?
Well, I think there are. So I distinguish between tentative and definitive. These findings are certainly not definitive, because we didn't go into anything like the depth of detail that one would need to do to produce clear-cut answers to these sorts of issues. I regarded this as an exploratory piece of work. It's not tentative in the sense that, you know, if you said, if you were writing it again, would you do it differently? No, I'd do it the same. I would say the same things. So, I mean, in relation to federal systems, there really are some quite substantial differences that I think do make it difficult to generalise within, you know, a space of, say, let's say we've got 5 pages to write about Australia. You know, it's there are a lot of states there, and they really do differ quite substantially. And in those circumstances, given the sort of space and time limitations we had, we weren't able to drill down into those differences. But I think I'm not tentative in saying that those differences exist. They certainly exist. As to the robustness of the EU data, well, that's true. I mean, I think the sort of exercise that the Commission of Europe did in producing their comparative statistics, they did get a lot of criticism from people for the sorts of assumptions that they'd made. But if you're going to make any comparisons of case volumes, of costs per case and those kinds of things, you have to make heroic assumptions and produce rather broad brush kinds of findings. And I would certainly be the first to say, well, yes, this is broad brush kind of stuff. Then if I were if somebody said, well, we've got a green paper on the reform to the legal aid system, could you use what's in my report as a reliable guide? I would say, well, no, it's a starting point, but there's nothing in that, I think, which would lead you to do anything other than be quite nervous about sort of taking on the kind of range of reforms that are in prospect.
Just to be fair, you've said yourself that additional analysis of data collection methodologies might have revealed other explanations, to be fair.
Yes.
The Minister of Justice specified the comparator countries that you've studied.
I did.
By what criteria were they determined?
My understanding is that the two things they wanted to do were, first of all, to compare mainland Europe with some of the Commonwealth countries, with some of the common law jurisdictions, because there was a worry that there was something about the continental countries which meant that legal procedure was an important component in the cost of providing public provision for legal services. So I think those were the two principal criteria.
Would you have found it more useful to do a worldwide comparison? It would have been a big piece of research, I'm sure, but could that have concluded, or would that, do you think, have concluded that the system in England and Wales would be the most expensive?
Well, I suppose insofar as we were concentrating primarily on middle and higher income countries, we included quite a large range of those, certainly most of the major European countries. We didn't cover the United States, which would be a very large and messy piece of work to do because of the state level jurisdiction. The other countries would be perhaps Japan, which would have such a different legal system that I'm not sure that there'd be a sort of great deal to be learned from. I'm not sure, but that would, okay. I'd be hesitant about that.
Could you tell the committee then what impact does the reintroduction of means testing in criminal cases have on your findings?
Well, it's quite difficult to produce a quick and easy answer to that. I haven't looked at the business case that the MOJ will have had for making that change. It's certainly the case that there are in other countries that there is means testing in criminal cases, and that in some countries in a sense it goes even further than that, and that you don't get anything if you're convicted for certain sorts of offences. There's no entitlement at all, whatever your level of income. So I think the answer would be that one would need to look to see what kinds of cases were being turned down, what the change in the proportion of or what would be the proportion of cases where contributions were being sought from defendants. So I couldn't give you a figure off the top of my head, I'm afraid.
Mr. Governor.
Thank you. Just two very quick questions. The first is, if I may ask a personal question, how much of this cost? And you mentioned about
additional research and be able to come to more definitive conclusions what the cost of such a study might be? I mean, I don't want to put a price tag on it. And I have the second question after that, but
well, I think it would depend very much what one wanted to do, because it seems to me that in a sense there are two issues here. And what we did in this report was pretty much to document the way in which arrangements work in other countries, some of the sort of key features of them, and as it were, sort of demonstrating that there are some countries that do things very, very differently, and that there can be very big cost differences that one can attribute more or less directly to those kinds of differences. I think what seems to me to be the more testing question is how could you, as it were, learn from those experiences and transplant them into England and Wales? Because I think that, if you take something like the sort of ceiling income entitlement, suppose that you were to reduce that by 2/3, that would be an enormous change to make. But knowing, sort of being able to track through what the consequences of that might be, I think is of a different order from doing a sort of more descriptive study that looks at the way that different countries operate their legal systems at the moment. So I think that there are, as it were, there are different things one could do. One would be to do a more to sort of go further with the kind of study that we've done here, and to look in greater detail at particular areas of law, for example, and make comparisons across those between countries. The other kind of exercise is a bit more like the kind of work that I thought I was going to find in the impact assessment for the consultation paper on legal aid, which is to say, well, if we do this, what kind of world are we going to be looking at in 3 or 4 years' time? But I didn't find sort of much indication of that in the impact assessment, and I think that that would be a sort of that would be an interesting piece of work to do, but it would be somewhat different from a more thorough, as it were, sort of encyclopedic piece of work looking at what the...
Just a quick question on the intriguing suggestion you put here about kind of non-voluntary pro bono work by lawyers. Does that, without going into too much detail, did that have an appreciable impact upon the legal costs in the places where that was...
Well, I think the sort of the context for making that remark really was that in certain parts of the US there are, for example, law firms which do quite large amounts of pro bono work as a kind of a quid pro quo for certain kinds of they know they're well off, and I guess it's their way of putting something back. Let's put it that way. And that in a sense that's one of those areas where you could, as it were, you can reduce legal aid spending by inducing people to supply services at zero user cost or at low user cost. But the question is, who then pays? Is it the clients of those law firms who are paying for other kinds of legal work to be done, or is it because without being unduly cynical, it's probably not the lawyers themselves thinking, well, corporate law is such a doddle, I've got a lot of spare time, I'd like to put something back in the community by doing some pro bono cases. I think it's a
running short of time. Very quick point.
Very quick on a point of information. You may not be aware of the substantial pro bono work that already goes on at the bar with solicitors, for example, the bar pro bono unit, which can be of help to members of Parliament with their casework. But I just want to ask you and draw something out of you about the timing of your research. The control period of your research ends in 2007, does it not?
Yes.
And the Council of Europe figures demonstrate a nearly 23% decline in spending on legal aid in England and Wales in the period since then.
Yes.
Does that have any impact upon the conclusions that you come to as of today?
Yes, I think that's an interesting question, and I've asked myself that over the last few days. With not really having kept up to date with this field since I did this piece of work, I'm not absolutely certain. I mean, I think the two things I would say is first that the first exercise to do would be to look more closely at the MOJ figures for how things have evolved in England and Wales. There are also things like changes in exchange rates, which mean that some of the relativities would be somewhat different now. And there's also the fact that there has been there have been changes in the pattern of work that's being done under legal aid, and one would need a bit of time to reflect on what the consequences of that might be.
And finally, just one question, if I may, Sir Alan. The Council of Europe report shows that when you look at courts, public prosecution and legal aid together, England and Wales is actually at the average when it comes to percentage of GDP per capita spent on legal services.
Yes, that's an interesting observation, and that's why I think more needs to be done about sort of trying to track through what the implications of some of the proposals might be for the volumes of work that might be anticipated under the new proposals.
In the report, you attribute the cost difference on the court side primarily to, or you speculate that it may be primarily because of the use of lay magistracy and the very small numbers of professional judges.
Yeah.
Do you still hold that's the likely?
Yes. I mean, I think that's what one needs to be a bit careful with that argument. It's not just that the time of those people is paid for in a different kind of way. It's that if you've got a professional judge sitting in a court, then the way that the case is presented and the issues that are looked at and the way that the defendant, or the part the defendant and the prosecutor play, is somewhat different, and I think it's a little bit. I mean, there seem clearly to be possibilities for substitution here. That's to say that you could have the court do more inquisitorial work itself, and the consequence of that might be that you would need less by way of representation, and that really goes to the point I was making about legal aid not really operating in a vacuum. It's derived demand in a market for legal services, which is itself propelled by all sorts of substantive and procedural things to do with the way that the legislation operates and the way that the courts work.
Thank you very much indeed. Very great too. And there was something you promised to let us have a note about, wasn't there?
Yes, a note on guardians.
Yes.